Okay, we can begin with it then.
Yes.
Okay. So, good morning and welcome to the very first episode of Me-Arcone Queuing Season 9, brought to you by the Institute of Alternate Dispute Redressal, an organization committed to turning conflicts into constructive solutions by advancing the role of mediation beyond traditional courtroom. I'm your host Vaishnavi Upadhyay from Asian Law College, currently interning with in ADR. It's my privilege to lead today's session that is Beyond the Courtroom, AI, Mediation, and the Future of Dispute Resolution. Today we have with us is someone who is quietly transforming the way India thinks about justice, a third generation lawyer who chose to step away from the courtroom, Mr. Mohit Mokal. He has built his career around mediation, believing that the best resolution often happen outside the adversarial walls of the courtroom. Armed with a law degree from Jindal Global Law School and a master's international dispute resolution from Queen's Mary University of London, Mohit has worked alongside legendary mediators, designed a mandatory mediation course now adopted by Indian law schools, and pioneered AI powered tools such as Ask MMM and Just AI to bring conflict resolution into the digital age. Fluent in English, Marathi, and Gujarati, Mohit bridges cultural divides as easily as the legal ones. Whether he's training the next generation of mediators, coaching individuals through conflict, or helping organizations embrace technology in dispute resolution, his work is guided by one core belief that is justice should heal, not hurt. It's an absolute pleasure to welcome to the show. Welcome to the show, sir.
Thank you, Vaishnavi. Happy to be here.
So, if you may allow, we can begin with the segment one.
Yeah.
Okay. So, sir, there has been a constant questioning between all the people who want to pursue mediation or who want to pursue ADR. So, sir, my question will be wholly related to the mediation itself. That's how mediation works better in many cases compared to that of other litigation procedures.
Um, I think this comes from this gentleman called Dr. Frank Sanders. And if I remember correctly, around the 1990s or something, he came up with this concept of the multi-door court system.
Okay.
Where the court is not just one institution where you go for litigation, but it's a multi-door institution that has appropriate processes for different types of cases, right? And in that light, even today we see that of course there are cases that require some clarification of law, maybe at times instruction from the court to do or not to do something. Maybe it requires some detailed insight or policy making or something where it is actually essential for the court to intervene, to apply its mind, to hear the arguments, and then to give a judgment. But a lot of cases are also capable of being resolved through arbitration, where you don't need a supreme court or a high court judge or even a district court judge to be hearing your matter, because there is no interpretation of law that needs to be applied in a much stricter sense. There might be application of law, right? Several times it's only about giving directions, right? These can be sought through commercial means, through commercial arbitrators, right? And in today's world, we also have, in the banking and finance industry, we have ombudsmans, who are like a neutral third party who give decisions. In HR, we have in workplaces, we have the HR who usually does dispute resolution amongst the office. And so there are, alternative ways than litigation in the strict sense. So in today's time, commercial disputes for the most part are going towards arbitration. Um, there is also, cases where, for example, and this was also highlighted by the Supreme Court in Afcon's infrastructure versus Cherry and Markey in 2010, where they said that there are cases that are more suitable for mediation, where, for example, parties have a personal or professional relationship, where they have known each other for some time, or they could continue to benefit from each other's association. But it's because of, some issue, some dispute, maybe an ego, maybe not being on the same page about some events. These could obviously misunderstandings could lead to a lot of issues or disputes as such, and not all of them need to go to court, or not all of them need to go to arbitration. A lot of them can also be resolved through simple dialogue or facilitated dialogue through mediation. And that's what the multi-door court system talks about, where these processes like, litigation, mediation, they are not two sides, sorry, they are not separate. They are in fact two sides of the same coin, that where some disputes are more appropriate to go to court, while others may be better suited to be resolved through mediation.
Thank you so much, sir. Definitely, you enlightened us with a lot of stuff. I was not aware about the multi-door court system. Sir, if now you have already discussed the segment one, that was why mediation works better in most of the cases. So now we can switch, if you allow, to the segment two of the session. So the segment two is basically linking the AI with the mediation. As we are already aware that you have developed some tools like Ask MMM, Just AI. So if you could just enlighten that how these tools work and what are they exactly and how they're changing the game in the name of mediation.
Sure. So let me go a little chronologically. First came Just AI and then came Ask MM. So the idea with Just AI was that in the attempt to raise awareness about mediation, right, as lawyers or mediation advocates, one might have, tried to explain to their client the costs and time of litigation, arbitration, mediation, which process is most likely to lead them, to the best result. And a lot of parties who don't have access to lawyers are also looking for the same information, right? Um, Unfortunately, several times, maybe lawyers who are not fully aware themselves may misguide parties to certain litigation, right? For any, and this is, India is a litigious country, let's not hide away from the fact that most disputes are still going to court. And so there is a little bit, I feel, of a lack of awareness and information, right? So how Just AI came to fix this lack of awareness and information. What it does is, let's say a user has a debt recovery dispute, right, in Bangalore. The user can put up their basic details in the website, where you put, okay, the value of the case, how many people are involved, since when is it pending, do you have documents, evidence, etc., what jurisdiction are you in. And the tool calculates your estimated time, cost, and probability of success across litigation, arbitration, and mediation in a comparative table. And so the user can look at all this information and make a more informed decision as to which process is going to be faster, which is going to be the cheapest, and which is going to give me most likelihood of success. And so, as a second step, once the user has this information, we also ask them if they need to be connected to a legal service provider. So legal service providers are filtered based on the user's language preferences, budget, areas of specialization, experience, etc. And then the user is given 4 to 5 recommendations of legal service providers who they can connect with to facilitate these services. Or let's say if they want to try arbitration or mediation, then they can do it through these service providers. Um, so this was the Just AI tool to raise awareness and to connect users through legal service providers. The second tool is called Ask MM, and Ask MM is an AI-powered mediator that helps a variety of users with dispute resolution, including individuals who have disputes, students who are trying to learn about mediation and negotiation, or professionals and mediators, lawyers, mediators who could use a dispute specialist in their life. How AskMM works is it is powered by large language models, that use natural language processing. It is fine-tuned on specifically curated negotiation mediation data sets that includes a lot of case-related data, learning, training, educational data, publicly available information, including case laws, training material by the MCPC, and even ethical modules that guide on how to connect and how to communicate with users. So how AskMM works is, let's say a user comes with, I have a problem. Ask MM can help you break down that problem and help you prepare a negotiation strategy. If you want to practice this strategy, you can ask MM to simulate it by role playing the other side, and you can either practice the whole session, you can practice a part of the session. If as a mediator you want to practice your skills, you can ask MM to teach you about the process, to teach you how does a mediator open, how does a mediator break an impasse, and Ask MM will, facilitate that learning through creating these scenarios, letting you learn, and it will also give you feedback on how you did well, what you can do better, etc. For professionals and users, it can make, having difficult conversations easy. You can brainstorm, real life disputes with Ask MM and get advice on how, what could be a better way of resolving this. Uh, of course, AskMM has a larger institutional use as well. Currently, we are licensed, commercially licensed by the International Arbitration Mediation Center, Hyderabad, that are using AskMM for their mediator training program, assessment and evaluations. So people who are, completing the training programs, they have the option to be evaluated by AskMM, and AskMM generates the training reports, gives them feedback, and decides whether they have sufficiently met the criteria to pass, or do they need to try again. Alternatively, we are also in discussions of promoting Ask MM as an AI based mediation service provider through ODR service providers in the country, and how AI based mediation can be integrated with ODR is what we have to find out in the next few months.
That's a huge that's a huge step that you're going to take, definitely, because nowadays that we can see that our generation specifically, there actually we are mostly dependent on ChatGPT for our answers, whether it's day-to-day life or whether it's something else. And asking ChatGPT, which is something related to legal fraternity, mostly ChatGPT says that thing that I'm not responsible and I'm not the lawyer itself. But still, people do search it. Like ChatGPT is the new Google for this generation, and introducing an AI-based ODR, that's a huge step that you are going to take. So, and I'm already just AI and Ask MM is a huge step that you have taken towards digitalization of mediation, and that will surely make a huge impact, and that has been making an impact already. So, sir, there's one more question that has been arising in my mind lately, and that's key. Are we able to balance the human emotions and empathy with that of AI? Because you are thinking to bring the AI into this picture. And like, let's be very general. If we take an example, most of the cases, like 90% of the cases, are majorly the marital dispute that goes for the mediation in Indian society. So, are we able
Hmm.
to manage the empathy and the human emotions with that of AI?
Right. Now let's think about, how human emotions impact a mediator's or a advocate's ability to manage, right? I'm sure you must have heard that in the medical code of ethics, doctors are usually not allowed, or it's recommended that they don't operate on patients that are theirs, that are family or friends, right? Relatives who they may have an emotional connection with. Similarly, the reason why lawyers are, representatives of clients in the court, or their advocates, their counsels to give them advice, is to give them advice from a neutral point of view, from an informed point of view, a professional point of view, right? And while yes, of course, there is a human side to hearing clients, to allowing them to express, letting them be heard, asking them questions that make them feel comfortable, and that bridges this trust between a lawyer and their client. And so while that part of allowing the party to express themselves, um, and retaining your neutrality, retaining your professionalism, right, it is in most cases, it's difficult to balance for any person, right? And it's challenging. And so, like, it's challenging for us, I'm sure. A lot of us might be able to do some things right all the time. Sometimes we might not be able to do other things, right? So while this is a human limitation, and this is just called being human, right? It's the human condition that we aren't always able to do everything exactly how we must. But with AI comes a little bit more consistency, right? With AI comes consistent quality of ethics, consistent quality of dialogue, consistent responsiveness. For example, if you and a close friend of yours have been talking about a personal issue that they've been experiencing, and your friend keeps coming back to you with the same issue again and again and again, while time and again you've had this conversation, eventually you are going to get frustrated, right? And you might throw a tantrum. But an AI powered bot won't. An AI powered bot will show empathy again and again and again, and will not have those human limitations as such. So um, while AI maybe 2 years ago was not there, where it could have an emotional intellect, or as empathy as such, I think technology is rapidly developing. And while of course it's difficult to say how you can quantify human emotions, but the speed at which AI is learning would surprise most people. um, in today's time, of course, there are specific modules you can create for AI bots, including an EQ, an emotional quotient, emotional intelligence, how to communicate with humans, and you can give it samples of how people have communicated, and how it makes them feel, right? And so it has the way that you can teach it to learn to express and understand emotion. um, so yes, of course, while there may not be a perfectly, this is the perfect emotional quotient, or this is what it can do exactly like a human, but it is learning very fast, and I think there is much progress that's been made.
Thank you so much, sir. And definitely, you have actually mentioned this thing that as a human, we are not able to balance everyone's emotions. So how come we can expect that from an AI? But definitely, AI will be much balanced compared to what we humans are, because we actually get disturbed by a lot of things that's happening in in front of us, happening in the environment itself. There might be a lot of things that must be disturbing, and that comes out in a very different form. But AI might not be frustrated if my friend runs to that AI continuously, but I might be. So, if you are clear about everything in segment two, so we might move to the segment three part, sir.
Yeah.
Okay. So, the segment three basically deals with the mediation and how it should be why it should be the norm. It should not be the alternative. Like it is termed as alternate dispute resolution or redressal. So, why it should be the norm? And what's your opinion in it?
I mean, I think there is already some good wisdom on this. I'm forgetting who framed this, but I think it was yeah, mm, like we discussed in the first segment, when Frank Sanders said it's not alternative dispute resolution, it's appropriate dispute resolution. So of course, I am a advocate for mandatory mediation. I think the model has successfully worked in several countries, and especially in India, where we have such a large pendency of cases. Like it's abysmal to think about litigation, entering litigation at this stage, right? Of course, we need to encourage mediation as the primary step of dispute resolution, and of course, there are several safeguards on this, right? You could ask for uh, mediation as a simultaneous dispute resolution, where you file your statement or your claim in court, try mediation until your matter is listed, right? If it fails, you continue with the case. If it succeeds, the judge orders the case closure as settled, right? But we don't try that. I mean, of course, the pre-institutional mediation rules have made somewhat of a positive impact. Recent judgments by the Supreme Court have affirmed that the requirement is mandatory, and that you cannot, just circumvent the mandatory requirement by filing an IA. Even after the IA is resolved, you must go back and try mediation. I think it was called partial automation. Uh, and so there is a huge chunk of cases. I think when I did a study around 2020, I had remembered that it was only around 3% of cases that went to mediation out of all the cases in the High Court of Karnataka at the time. And I don't think the statistic is much higher in other jurisdictions either in India. That being said, out of these 3% cases, I think 90% of them go to uh, court annexed mediation, and only a fraction of them go to private mediation. Or so this number has to rise. Private mediation, institutional mediation, online dispute resolution. Mediation needs to, the public needs to have access to mediation not just through the court or through court annex centers, but through private mediation service providers. And once, the institutions adopt mediation, once the government promotes actively mediation, like currently we are having, the Supreme Court is promoting the special mediation drive. So initiatives like this that bring mediation to the forefront, uh, you know, are a step in the right direction where, if strongly supported by institution, people, the industry, and the government, only and only then can mediation truly, make the difference that it's supposed to. Otherwise, it risks, becoming like arbitration, where it becomes another process in the step of the court.
Definitely, sir. Mediation. I read somewhere that I guess in Italy there's an opt-out mediation service that they made in
Mhm.
mandatory in the.
So the government, yes, if I can add a little bit on that, in 2010, Italy made mediation mandatory. It was quickly challenged, and in 2012, the Supreme Court clarified that it can be made mandatory, and it is not, infringing on the rights of the litigant, because what is mandatory is not to settle, but mandatory to participate. So you must participate in the first session. You must sit before the mediator and the other side and attempt to make a resolution in good faith. If despite an attempt you fail, it's all right. But if you don't go there, if you unreasonably refuse to participate in mediation, there are also incentives and disincentives. For example, incentives could be that in Italy, for example, if you settle a dispute in court, you also get tax benefits. In India, some if for court annexed disputes that are in court, if you get them settled, you get a refund of court fees. Right? In some jurisdictions, especially in the UK, I think it was the Justice Wolf recommendations on civil litigation, where they said that for parties who unreasonably refuse to participate, would be sanctioned and would be awarded, the costs of litigation. So if you have refused to participate in mediation and then gone on to even lose the litigation, the costs of the entire litigation would also be put on the losing party for refusing to mediate, for refusing the opportunity to try and settle it in the first instance. So those are the kind of incentives and disincentives, we could also consider implementing over here. But again, that's a policy, discussion.
Definitely, sir. Thank you so much. Now we'll switch to your personal vision and values that have actually moved you towards mediation. So, if you could share, because you have worked with Sri Ram Pancho, who is one of the most legendary mediators. And were you as a law student, from one law student to another, I wanted to ask, were you as a law student inclined towards mediation since very beginning, or it was just a mere experiment that you wanted to do?
Well, honestly, I had tried mediation since my second or third year, but I was also, fascinated with arbitration at that time. Around my final year, I was frustrated with arbitration as well, and so I took a mediation internship where I discovered how it was, and so that's when I decided to switch completely. Of course, I still, think arbitration is can be used as a successful tool of dispute resolution if the flexibility is adopted, if the uh, process is swift and smooth. uh, the arbitration is certainly helpful, uh, and so I do have a master's in international dispute resolution as well, specifically in commercial arbitration. But in India, my practice delves into finding a solution for your client, right? Your client needs a solution. They don't need you to litigate. They don't need you to arbitrate. They don't need you sometimes to even mediate. They just need you to find a solution for them. So using these different processes as tools in your toolkit, you know, you a lawyer must equip themselves with all the tools required to, find a solution for their clients. And so that way, one must learn not just, these things, but many others to find the best possible solution for your client. And that's how you get, happy clients keep coming back and they trust.
Thank you so much, sir. It was definitely a wonderful session, and that this brings us to the end of the insightful session, the conversation on beyond the courtroom, AI mediation, and future of dispute resolution. I extend my heartful thanks. There were a lot of things that I learned out of you. There's a lot of things my the audience will be joining who might would have learned out of you. So I extend my heartful thanks to you for sharing your journey, your expertise, and your vision for a justice system that heals rather than harms. To our listeners, thank you for joining us on the very first episode of Me-Arcone Queuing, powered by the Institute of Alternate Dispute Resolution. We hope today's discussion has sparkled new ideas about how technology, empathy, and innovation can come together to create more accessible and humane path to resolve disputes. I'm your host, Vaishnavi Upadhyay from Asian Law College, intern at in ADR. Until next time, let's keep working towards turning conflicts into solution and making resolution into not litigation the first choice.